soon as he gets out, he'll be ready.
Okay.
Hello.
Morning, Judge.
Good morning. All right, so I'm in receipt of a motion for discovery and inspection. Did you review this with defense?
Yes, I have.
All right, any objections to any of the requests?
Just a couple, Judge, under section 1, I'm sorry.
That's good.
Under the first request, statement asked that exclude any work product. Whenever I meet with a victim, I do a summary of anything that may be related to provide that to them. Product, and I would ask not.
Our intent is not to ask for work product. My
So
concern though,
regards-
my concern in general, and not with Ms. Brown, because she is definitely thorough. And then as you'll see, I think she's gonna put in another disclosure. I think if there's a statement that that's not work product. And so her notes may be work product, but the statement is not. And so I just want to make sure that if there is a statement that we're aware of it, and then definitely if there's nuanced differences or differences between that statement and what we received, that we receive that.
Well, with regards to your notes, are there a synopsis of the meeting? Or are you taking word for word?
Oh, no, they're synopsis. They're literally just like quick jot down. Somebody will say something and I'll jot down 2 words. And then I'll go type something that will be thorough using thoughts and put full sentences together.
All right, the court then is excluding the work product. Counsel, if you feel if there's something, I can do an in-camera inspection.
Thank you, Judge.
All right. All right, we're gonna go on the record in 2023 CR 2023 CR 8101 State versus Celeste Suarez. Can I have parties announced for the record for the state?
State.
Defense.
Jason Todd for defense.
And are you Ms. Suarez? All right, so off the record, with regards to number 5, motion for discovery and inspection filed by the defense. With regards to number 1, the court is granting that based upon the agreement of parties. It will exclude state's work product, but if necessary, the court will perform an in-camera inspection. All right, with regards to number 2.
Judge, there is none to my knowledge, but if I discover that there is, I will disclose it.
All right, that'll be granted. With regards to number 3.
State has already provided a witness list to defense. The only thing is we don't have personal addresses for the victims due to safety issues. We have for the officers and the school professionals, we have school addresses, the work addresses, and work information to the best of my ability. And if I find more information, I'll provide it.
All right, so the court, based upon the state's representation, do you have any objection to not including the addresses of the complainant?
Well, Judge, I understand not filing it in a public record. I also, though, I don't understand the safety issue of disclosing it to defense.
All right, so what do you want to do with the address? You want to go out to the address of the complainant? Is that in some way related to the alleged offense?
If there were reports we wanted to know if there's been calls to the house, if we wanted to do research on the complainant, we would not. That being said, we have the address of the complainant, so that's not the issue.
All right, so you already have.
I have that address, but safety concerns for if there's more than the complainant, we need the ability to research these witnesses, and we need the ability to know what's going on regarding their
Well,
testimony.
my understanding is the only thing the state is not wanting to turn over is the addresses. Is that correct?
So it's the addresses of the complainants, and I'd have to look over, I'm sorry, I don't have my witness list. It's the address of the complainant and complainant's mother, guardian.
Well, he says he already has the address of the complainant and the complainant's mother, so that will be excluded. You already have it.
And
Yes,
the
sir.
personal addresses of the professional witnesses, but they are identified by the workplace to the best of their ability. And if additional information comes, I will turn it over. I'm giving you the ready.
All right, with regards to professional witnesses, I'm assuming the professional address for their business. You don't need their home address, do you?
We do not, just the ability to contact them and reach out to them if that need should arise.
All right, I'm going to notate that defense has in its possession the address of the complainant's address, so that's not needed. So what I'm gonna order is that there is to be state, you're to turn over all the names and business addresses of individual witnesses. And if for some reason there is an address that you feel that you need, that is a person's personal address, just come back and we'll have a hearing.
Thank you,
But
Judge.
that'll need to be done, not at the last minute.
Understood, Judge.
Okay. Number 4,
To my knowledge, Your Honor, there is no informant in this case. If one becomes known to the state, we will disclose it.
all right, thank you. And let me ask you all this, is CPS involved in this or no?
Yes, Judge.
All right, so sometimes the confidential informant could be the person who reported it.
So CPS comes in after the initial report to law enforcement. I think, was it law enforcement or without CPS, I think?
I would have to look at the timeline. CPS is, we know who told CPS. I will say that. I don't think that's an issue in this case, Your Honor.
All right. Because if it is, then my ruling on this, granting it, I'm going to rescind that because that's supposed to be confidential.
I understand, Your
All
Honor.
right.
I don't think that's an issue, though.
All right. And number 5,
As to number 5, Your Honor, the only issue state has is.
everyone, please whisper. And everyone, we're on the record, so no talking behind the court reporter while we're on the record. All right, number 5.
The only issue is the rank and badge number of the police officers. Some of them have changed agencies, some of them have retired. I don't have all of their badge numbers or rank. As to what information is current and that I can provide, I will provide it, but I don't have all their historical information for what their rank was. And I also don't know if he wants rank at the time of the offense, badge number at the time of the offense, future badge numbers. It's a little vague for me.
I guess my response would be to that if she gets updated information and she's talking to her witnesses, if we get to the place where we're prepping for trial, we need the ability to know where her witnesses are. If she's, I have no doubt she's given us what she has, but if she finds out something new, I think we do
Okay.
need to know that.
So as far as where her witnesses are, that would be taken care of with regards to defenses number 3. So do you really need to know the rank and badge numbers?
Yet the rank is helpful, but the badge number is important because if this law enforcement officer has moved to a different agency or within the agency, if we want to look them up and look up what they have, perhaps discipline or get information from the agency, I have found the easiest way is a badge number.
All right, so you don't need their rank.
I guess I don't need it.
All right,
It does.
so then if you have the rank, then give them the rank. But if you don't have the rank, then she doesn't have the rank. And it is vague based upon what she's stating. Do you want their rank at the time they were involved in this, or do you want their rank now? So if you have their rank, give it to them. If you don't have the rank, and if there's an issue, then just come back to the court. If you have their badge number, give it to them. If you don't have their badge number, then come back to court.
Thank you, Judge.
And I'll write that the defense is to approach well before trial if there's an issue with the rank and badge numbers.
And if you, Judge, I have my phone out, but I'm just taking a note.
Sure, no problem.
Thank you, Judge. Thank you. Thank you, Judge,
You're
for
welcome.
that indulgence.
All right, and then number 6.
There's no issue with that request, Your Honor.
All right, is there anything else?
As to the motion and the specific order attached, Your Honor, I would just ask that if the defense needs to physically pick up any tangible items that are not able to be transferred via e-discovery, that they come pick them up here. They're in the building every day, and I don't have a work vehicle to take them to the office.
Okay.
And we're fine with that, Your Honor.
All right, so I'll put on here. All right, so State, have you gone through each order that they're saying they want 48 hours, within 48 hours of the time it learns or obtains discoverable matter?
Yeah, Judge, if it's within 20 days prior to trial, yes, we're gearing up for trial, that's fine, Judge. I'm pretty,
All right, so you've read through the order and you have no objection to the court signing the order as is, but the court will add the line that if there's anything that needs to be physically transported, the defense needs to come and pick it up from you.
that, and just with the provisions regarding the product, if that's somehow incorporated into the order, that will probably not be turned over without being.
All right, so if you all will write the additions to the order, the court will sign it. And then all of the other discovery has been tendered.
I'm sorry, what was that?
All of the other discovery has been tendered because the last time we were here, it was the complainant school records, CPS, any additional records, the IDR, dispatch received, calls for service, statement made by the school nurse.
So regards to those items, Your Honor, we had turned over CPS, defense police, there's items missing. We're gonna send a more specific to Davina to specify those items and see if they're turned over. There was some body cam that defense believe existed. We asked about it. I just found out this morning that that body cam does not exist any longer. It did once, and no longer does. We're getting an affidavit of no record, and I've provided a written disclosure to defense regarding the restriction. As far as the IDR, CAD, all of that, there's one thing that relates to those items, and we have turned that over to defense. The nurse's statement was turned over. We clarified with the nurse or with the detective that the only statement made by the nurse was the nurse's reports. And so we've gone through those items. The only outstanding issue is the affidavit of no records for those body cam videos and the requesting the CPS to see if there's additional material that can be displayed, can be turned over. We did request all CPS records prior, but sometimes if you don't specify videos, documents, etc., sometimes they don't want them to.
All right. Defense.
That is an accurate depiction of where we're at, Your Honor.
All right, so this is what's going to happen, and this will be your last setting for discovery. And if there are items that are missing, or you see that when we have this next hearing, that there are going to be items that are missing, you need to subpoena witnesses to have them here. They can appear by Zoom if need be, but this will be your final discovery. And also on this date, state if you have not, you'll need to tender an offer to the defense.
We are in negotiations with the federal government for longer. I don't think we have a firm one at this point, but we've been talking.
All right, so Ms. Ferguson, recall this for March 27th.
I'm sorry, Judge.
Yes.
I'm unavailable on that date.
Okay. Oh, I'm so sorry to hear that. What is a good date for you? I was just trying to give you a longer setting.
I'll be back the following week, the first week of April, Your Honor.
Right. Norma, put this then on April 1st. And if you all don't have the remaining of the discovery, then witnesses will need to be subpoenaed to be here on that date.
I'm so sorry, Judge. What was that date?
April 1st. You're welcome. And defense, if your client wishes to appear by Zoom, your client can appear by Zoom.
Thank you, Judge. We appreciate that.
Okay. And what page is she on, Ms. Ferguson? All right, if you can have a seat. Thank you so much for dressing appropriately for court as always. Just have a seat and the coordinator will bring you your reset form. And once you sign the reset form, you're excused.
Thank you. Have a great day.
All right, thank you. You too.
In custody. Yeah, he's in Tuscaloosa County.
I don't know. I was like, you got to.
Yeah, no, but yeah, he's in Tuscaloosa County. We'll figure out that.
All right, counsel, you're on this side.
Thank you, Your Honor.
Why were you late for court?
I haven't been downtown or to court.
I'm sorry, what?
I haven't been here in a while, so.
All right, so don't be late again. You
Yes,
now
ma'am.
know where it is. You understand? All right, where are we on this case?
Judge, I have asked the prosecutors to take a look at the body worn camera I think it was, the version I have, I think is too short.
Okay.
Also, I asked them to look for co-ban, even though the Senate Bill 111 indicates there is no co-ban. It's kind of strange. It's a lieutenant doing patrol, which is kind of strange.
Mhm.
Also, there are some pre-filed cases that have yet to have labs come back on them.
All right, what, these pre-file cases, what are they?
There are 2 drug cases, Judge,
And what is the alleged amount?
4 to 200.
All right. All right, Ms. Ferguson, recall this for discovery on March 31st. And state,
Yes.
do you anticipate having the labs back on the other cases? When,
Surprised before, surprised again.
all right, so let them know that I want to be surprised. If you can call them and tell them the labs are needed for that. All right, thank you. Is there anything else?
No, Your Honor. Thank you.
Right. You can have a
Appreciate
seat once you sign the reset form. You will be excused. And I can't believe you're in here with a Texas A&M top and you're in front of an LSU's Tiger.
I'm sorry
I don't
about
know.
that.
I don't know. I don't know.
I have a piece of paper to you.
That's okay. We're cousins.